he was not at the robbery. He was not in the car. He had no idea that Smith and his buddy, who came with Mr. Advick, had a gun. He did not think that someone was going to get killed at this event. But he did accept responsibility for giving this young woman's phone number and saying that she would be an easy target for a robbery because she was selling cannabis and had cash. And he accepts that responsibility. But not only does he accept the responsibility, and not only did he plead guilty to the not murder count of this case, but also he lives every day with the knowledge that a woman was shot and survived, and the person she brought as muscle was killed. He knows he wasn't guilty of murder, but he feels a responsibility for the injury to a person and the taking of a life. And I know that because I represented him in the trial court, and I've represented him until today.
17-year-old Niles North varsity swimmer was shot and killed in Skokie last Sunday in what appears to have been a botched robbery attempt of a friend he was with. And now comes the news that two of those implicated were his friends, one of them in particular.
When they were on the swim team together, this individual was a couple years older than my son, very much a mentor to Max. So to think that somehow this individual was involved in the murder of my son is devastating.
Charged in connection with the murder are Zavad Avdik, Jeremy Lai, Miles Hughes, and Nicholas Smith, all of them 19 years old. Avdik and Hughes are Niles North graduates themselves. In court today, prosecutors said it all started when Avdik decided to rob an as of yet unidentified 17-year-old girl he'd agreed to buy some marijuana from. When they met last week, Max Godot was in the car with her, but apparently not involved in the deal. When she refused to simply hand over the drugs, prosecutors say a fifth suspect, who's yet to be arrested, shot Godot in the back and the 17-year-old girl in the face.
And we are about to watch the parole hearing for a man who wasn't even there at the scene of the crime that happened all the way back in 2014, a complete tragedy. Someone, 17-year-old, trying to do a side hustle, make some money selling the devil's lettuce. She was betrayed by her own classmate. The man whose parole hearing we're about to see now, he told his buddies, he said, hey, this would be an easy score. I imagine, he said, look, you can just go in there, take the ounce of pot. Maybe she'll have some cash on her. She's not going to be able to call the cops. It will be fun. It will be quick. It will be easy. Well, it seems that they brought along some men who maybe they didn't know that well. And that man allegedly pulled out a gun and shot her friend in the back, killing him, shot her in the face, nearly killing her, and then left the scene of the crime. Now, what's interesting about this case is that man who allegedly pulled the trigger, he was found not guilty by a jury of his peers. He never spent a single day in prison. Yet the others involved, they have been given long sentences, even though they testified against the man with the gun. This is one of those interesting cases, and we are about to watch the parole hearing again of the man who wasn't there at the scene of the crime, serving 20 years. Will his attorney, who urged him to take the plea deal, get him out? He is here right now at the parole hearing. Will the Illinois Parole Board find that he has done great in prison, find that he is deserving of parole? Well, we're about to find out, and I'll unpack it with more details at the end.
Mr. Chairman, ready to go? Thank you, Mr. Chairman. And once again, as we continue going down the site here, and I want to commend Mr. Lee. Can you hear me? Mr. Lee, can you hear us?
Yes, I can hear you guys now.
There you go. I thought so. I saw that red dot go away. So moving on, I want to talk real briefly as to the institutional adjustments, as he has no tickets. He actually has quite a few certifications. He's completed a variety of programs. All the certificates are in the packet. Shortly, his counselor will elaborate on most of that for us, as you do have access to all of those certifications in your file. And his parole plans are, from what I understand here, is to return and live with his parents in the city of Skokie and the village of Skokie, as they would say it. And in addition to pursuing higher education, is what I'm told. But at this point in time, I'll segue right into counselor and let him pick it up from here, if you will, unless we have questions from our board members. But if not, then if we can swear him in, let's move forward.
Amy, would you swear them in?
Can you please stand and raise your right hand? Mr. Lee, I need you to stand and raise your right hand too, please. Do you solemnly swear or affirm the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Yes, I do.
You might want to hit your mic so that way we
Got
can
it.
record it.
Thank you. Be one of the first times in my life when someone said they couldn't hear me. But I'll turn on the mic. Acceptance of responsibility, performing extraordinarily well under the circumstances of his incarceration, presenting to you a strong parole plan are the heart and soul of Jeremy's case today. I will be brief, at least for me, not because I don't have many things to say, but because the strength of Jeremy's case is so strong that we pray for a finding of parole. Acceptance of responsibility from his contact with the police when they came to talk to him, to his agreement with the prosecution,
There he is.
from his contact to the police where they interviewed him and he told them about his role in setting up the robbery. He was not at the robbery. He was not in the car. He had no idea that Smith and his buddy who came with Mr. Advick had a gun. He did not think that someone was going to get killed at this event. But he did accept responsibility for giving this young woman's phone number and saying that she would be an easy target for a robbery because she was selling cannabis and had cash. And he accepts that responsibility. But not only does he accept the responsibility, and not only did he plead guilty to the not murder count of this case, but also he lives every day with the knowledge that a woman was shot and survived, and the person she brought as muscle was killed. He knows he wasn't guilty of murder, but he feels a responsibility for the injury to a person and the taking of a life. And I know that because I represented him in the trial court, and I've represented him until today. This is a young man who truly feels shame and disappointment and embarrassment to his immigrant family who came to this country from Vietnam to start a new life. And he lives with that. I mean, he lives with it. And I think Mr. Delgado would agree with me. But that is not who Jeremy is. Jeremy is not alone in his journey to freedom after prison. If the things that we look for when determining whether or not to grant parole are a plan, housing and shelter, He will live with his parents in Skokie. They love him. They've been involved in his case. They came to every court appearance of his case. They call me to find out the status of this parole application. And not only his parents, who don't really speak English, but extended family members, also Vietnamese, who are fluent or at least more fluent in English, call my office, write me emails, put Bin, who is his mother, on the phone and serve as an interpreter. He is not alone in his journey, and housing and shelter are there for him. Food and nutrition, similarly, are there for him. Health, he is in good health, and his family will make sure that if he needs a doctor, if he needs help in the health world, they'll do it. Work. Well, Jeremy is now at crossroads. That is to say, the Department of Corrections has decided that he can be in a facility that will teach him reentry skills. And he's learning and loving those reentry skills. Work. He found a kind of calling in life. He's working for a truck company as a salesperson, and he's closing deals, and he's enjoying it and learning from it. The crossroads transition, and he has thoughts on a new life after prison. And that those thoughts involve a good family, as Jorge Montez said a few moments ago about someone else, a upward trajectory in his life. He has earned so many certificates and worked hard to learn new things in his prison years. And those, I don't need to go through those, they're in his file. And if you have questions about them, I'll gladly do my best to answer them. His nuclear family, mother, father, sibling, encourage him. And that support is extraordinary. And the acceptance of his cousins and other relatives to his hopefully newfound freedom will be a great support for him. So he has living, he has nutrition, he has health, he has work, he has the support of a loving and extended family. This is a young man who was not in the car when the robbery took place, who did not know of the murder or the shooting of the woman who's been called number 2. He has this was a horrible mistake to say that this young woman was selling cannabis and would be an easy target and likely would have cash on her. And telling that to Ardvik, who set up the rest of the crime, was a horrible mistake. But it is one that the state's attorney recognized was not murder. I don't believe that there is an objection by the Cook County State's Attorney to a request for parole. We are here under the Juvenile Parole Act. He has served more than 10 years of his 18-year sentence. He is eligible for parole. He is a worthy candidate for parole. And I think now you should hear from him, and I'll be quiet.
Thanks, Mr. Stone. I will correct you. I think there is a protest from the Cook County State's Attorney's Office, which I can.
Thank you. Yes, but Mr. Stone, there is a protest letter from the Cook County's office adding a line to the first letter as to from Eileen Burke's office. So that's in the file.
I've not seen it.
And I have a question for you also in your own petition, and because you just made another comment, and now you have to help me understand. But let's hear Mr. Lee, unless I can go straight continuing asking counselor questions. Mr. Chair.
Hello, good.
Can we just wait 1 minute? Mr. Stone, we're going to give you a copy of the state's attorney's objection. We want you to be able to see that so that
Thank
you
you.
can comment on it.
Yeah, the second one is more detailed. I received that one yesterday in my computer too, Mr. Stokes.
No one's, I'm
She's
not
got it,
faulting you or the board, but no one sent it to me. I would have hoped that the state's attorney would have copied it to me.
Give him my computer.
Thank you.
Here's the copy of the first one we received on 18th. There's just a smidge of the difference of the opposition letter with a little bit more detail towards the end. This is the whole letter from the top.
Yeah. Actually, this is for the objection.
I believe this is the 18th. What one is this? This might be the 21st. Yep, this is the most recent one.
Thank you. Don't go. I'll give you your computer back.
And on that note, Mr. Lee, this is an opportunity to, this is Delgado again, and sir, just wanted to talk with you a little bit, and my first question for you is to first of all, let me commend you on what you've been able to achieve while you've been there, and your enthusiasm for yourself going forward. You're a young man. But also, I would also help me understand your thoughts on that particular night of that, what occurred, and in your own words, if you could assist our board members now that you have the whole board here.
Yeah, so that night, so long ago, to be honest, like what was going through my head through those couple minutes of sending those messages was really just, I wasn't thinking at all, just being in the moment and being in that situation. I wasn't thinking rationally. I think I was just being very, very young, immature, and I was not thinking about my actions at all and what I was saying, and things weren't just matching up with who I was as a person. I think I've had the time to really sit back and realize the mistake I made and how it wasn't really me as a person. I do accept and take responsibility for everything I did with those messages and the conversation I had with my co-defendant. And it's just, there's no really complete answer of what was really going through my head that day, because like I said, I wasn't thinking rationally when I made that decision.
Okay, were you of sound mind? Were you buzzed? Were you high, or was there anything going on in your life, particularly that week, since it was about a marijuana deal?
No, I think it was just, I was time in life just growing up, just trying to have fun and just talking to the wrong crowd and just not really realizing that, I was.
Well, help me understand. I'm a little confused, and maybe you're going to have to clear it up, because you're the only one who can. In this
Right.
petition and in other comments is made that you weren't there, but I just read statement of facts that said you guys hung out in the back cart of the seat and were smoking the cannabis. What did you?
Right. So I did not. So that night was a Sunday night, I believe. And yeah, I was not with that group of people at all that whole Sunday. The messages was in the morning with Abdic. Never met up with him. Never. The guys
Never consumed marijuana in that car is what you're stating to me?
when they went and did that, I was not with them after that. I had never even seen Abdic after when that situation happened Sunday. The last time I saw him after that was after we were already incarcerated. So I was never with him after the robbery happened. I had never smoked the weed that they took. I never saw it. He never even mentioned it to me out his mouth that he actually took the weed. So he never told me he physically had that weed that night.
Or
So
that
I
all
think
that
he didn't.
violence that occurred?
Yeah, correct. So when the robbery happened, we never discussed the robbery and if he actually did it and how he did it. We never had that type of conversation. So after everything happened, I didn't know the exact story of what happened. And I definitely didn't have the marijuana in my possession,
Okay, thank you for that answer.
of course.
Is there anything else you'd like to add for the board members to know? As I've pointed out that you would, if you, upon your eventual release, you would be going back to your parents' home in Skokie, and I do believe you do. The file had indicated there was a job lined up. You and I had discussed that. However, that was something you wanted to do, and you were going to go ahead and pursue the sales. You want to touch on that?
Yeah, so I'm currently at Crossroads ATC in the west side of Chicago. I've been employed since December. I work at a used car lot called Sigler's Auto Center, and we specialize in commercial work trucks. So what I do there is I market and do sales. I get on the internet, I post ads, I email, call, get customers in, and then I help close the deal, do the paperwork. And so basically I'm a salesman. I sell mostly trucks, commercial work trucks, but we do have regular cars there too as well. But that's what I'm doing right now. I've been doing that since December. If I do get the chance to parole out, I'll be right by work. It's right by my mom and dad's house, which I plan on paroling to. So I'll still be able to work there, and I like it. I'm learning from it, and see how that goes. And hopefully I could continue to do that as well as finish my education, because I was in school when all of this happened and feel like I should get back in the classroom as well.
Any other questions from members?
I have questions for Mr. Stone to start. So I was glad to learn that you were turning through the case so that you'd be able to address this. At the plea negotiation stage, what plea offers were made to your client and what were the terms of the agreed plea?
I had filed a motion to dismiss the murder charges because I did not think that the evidence against Mr. Lee supported a first-degree murder charge. We had a hearing on that. The judge disagreed with me. And so Jeremy and I were facing going to trial on a first-degree murder charge where the sentence would be 20 to 60 years at 100%, plus a firearm enhancement, even though he was not the person who discharged the firearm. There was a firearm used in the robbery. I sat down with the two state's attorneys, and we talked about, I had offered them, I think, 12 or 13 years on some other crime, like an attempt robbery. They rejected that, came back from supervisors and said 18 years at 85% on a discharge, let me look. I want to get this right. On an ag battery with a firearm. Jeremy and I talked about it. I know this was a hard pill for him to swallow, but it was so much better than the alternative of the chance of going to a trial on murder and losing. I love trials. I love going to trial, but I don't do it for my enjoyment. I do it for what's in the best interest of my client. And in this case, Jeremy and I agreed that a plea to 18 years, especially since it would be a parole eligible after 10 years, was appropriate. And we did. I want to say that the state arguing that a granting of parole would be disrespectful for the law, their words in their letter, quite to the contrary. I think granting parole to someone like Jeremy is the ultimate respect for the law. Our legislature has said that if you're under the age of 21 and you commit a crime and you've served 10 years, you're eligible for parole. That's not disrespect for the law. That's doing what this board is meant to do, and that is grant parole to the worthy and deny parole to those you don't believe are worthy. There was nothing in Jeremy's past that makes him unworthy for parole. He has no prior criminal convictions.
Thank you.
There was nothing in his current that says he's not eligible for parole. He's been a model prisoner, both in Cook County and in the Department of Corrections.
My second question is tangentially related to Mr. Lee, but may seem unrelated to you. But did you follow the trial of his co-defendant, Mr. Hicks, who was acquitted apparently, and yet he was identified by the other participants as the shooter? Do you know what his defense was at trial and what the reason for that acquittal was?
I believe that their defense was you can't believe the people who testified against him because they were involved in the crime themselves. It was a successful and surprising defense. I know from talking to the prosecutors who put their heart and soul into that trial that they were shocked by the verdict. What this board may not know is that Jeremy participated in those two trials. He was a witness, and that shows you how much he was embarrassed, ashamed, and acceptance of responsibility. And he didn't do it for any benefit. He did it because he could not believe that his conversation with Advic cost someone his life and cost the woman a bullet to the face.
Thank you, Mr. Stone.
If I may follow up on that, I just want to be sure his testifying in the other trials was not a condition of his plea deal, correct?
No, it was a condition of his plea deal, but it was a condition that we agreed to. I think we would have gotten 18 years without it, but
The reason I ask that is you say that he did it with no benefit to himself, but it was tied to a benefit, correct?
I didn't see it as a benefit. I saw it as a agreed upon condition that we agreed to.
Understood. Obviously, he was not in custody in IDOC until late 2021. Have we seen Cook County disciplinary records to ensure that there was no tickets during that long stretch of time? Was that discussed?
No, the only knowledge I have that reflects in the file is that he was, quote, a model citizen, rather model, person in custody.
Okay. Mr. Stone, are you aware, or Mr. Lee, did you have any tickets or anything that you need to make the board aware of from the Cook County records that are not before us?
I have in my notes no tickets in 10 years. No
Okay.
tickets, none.
Mr. Lee, no disciplinary issues while in Cook County custody at all?
There was one incident that was already addressed when I was there, and it was addressed at one of the courts, do recall. but that I did receive a ticket that was thrown out because I was in a room that had some contraband, and so they took both of us. When they did the investigation, they seen that it wasn't in my property or none of that, so they canceled that ticket and they dropped that. So that was the only time I had went through a disciplinary situation, but that was cleared off of me.
Okay, so no findings of guilt on any disciplinary tickets,
No.
just the one, okay.
Yeah.
Mr. Stone, you mentioned that Mr. Lee did not know that the other offenders had taken weapons as part of this. The petition itself, it's one of the two things he actually admits to, is that he told Mr. Avdic to bring a weapon.
It was a fake stain. It was a fake stain with a pole. It was the language in the phone call. And I think that means in.
Can you repeat that, Mr. Stone?
Pardon me?
Repeat it. Repeat what you just said. She couldn't hear
A
you.
fake stain with a pole. A fake stain meaning they were going to pretend that they were going to buy, but they were really going to steal. And with a pole, meaning if someone brings a gun, she'll give it up easier. But Mr. Lee, did not know that Advic had Smith or that Advic had Hicks coming with him. Those weren't people he knew, weren't people he expected Advic would have associated with, and those were the people who shot, killed, and wounded the victims of this case.
Okay. But just to be clear, he did instruct Mr. Avdic to bring a weapon to the robbery.
I think that what he said was that she'll give it up easier if there's a pole. Pole, P-O. No, pole, like a pole,
P-O-L-E.
P-O-L-E.
That's another slang term for a gun piece. Mr. Boland?
Okay. That's all my questions.
Yeah, because I want to follow up right on that. I was perturbed because I have the highest respect for you, but it's in your petition. And the one sentence that I just burned a hole in me last night was that Mr. Lee told Avdic to bring a weapon. So it's not specific as to be a zip gun, a knife, or a bat, or stick. And it couldn't go. So it was a situation. That's what I'm trying to help understand. It's in your position, and I was reading yours to have a feeling for client.
Mr. Lee told Advic that she'd give it up easier if he brought a pole.
Yeah.
That is uncontroverted.
Yeah, thank you for that answer.
Go ahead, Ms. Tyson.
I have a question concerning the parole plan. I understand he'd go to his parents in Skokie. Are they in good health?
Are they?
Are they in good health?
They're in good health.
And in the event that for some reason he was not able to stay there, what would the plan be?
Well, he's got a job. He's going to have gainful income, but at least in terms of the, excuse me. I'm sorry.
It's not a good look for somebody who's trying to impress a parole board.
At least in terms of the current situation, he has a place to stay.
Thank you.
I'm sure as he grows older and more independent in life, he'll want to move out of the nest. And we wish all of our children eventually will move out of the nest, although it doesn't always work that way.
Any other questions?
Sure.
Dr. Golovoker.
Yeah. Can you just specify when you first learned that there was a shooting? What
what was that unfolding of your becoming aware?
Jeremy, I think you can answer that question. How did you learn about it, and what did you do when you learned about it?
Yeah, so shooting took place Sunday night. Monday morning, I go to school at Oakton Community College in Skokie, and I'm just in the computer room and looking up the Skokie news, Chicago news, stuff like that. And I see it on the Skokie News website, and I was just shocked. Honestly, I didn't even realize like I could have been a part of this. It was just complete shock because I knew one of the well, I knew both victims obviously, but one of the victims I actually, knew his family, talked to at school. So it was complete shock. And I just remember I was with another friend at school, and I ran up to him, told him about it. He was shocked. Everyone was just shocked. And that whole day, everyone was just talking about the shooting. And that's how I found out about it, was through the computer.
Thank you for that.
Yeah.
All right. Seeing no further questions, Mr. Delgado, do you have a motion?
Thank you, Mr. Chairman. Mr. Lee, you've done a wonderful job in your self-development. What's subsequent to these unfortunate situations that escalated to a point of a death and a disfiguration? You've done well considering under that incarceration, and your discipline and program opportunities speak for themselves, as we have quite a few of your certificates here in that packet. Your petition is well presented, well written. You did engage in your self-development, Mr. Lee. Your lack of tickets are very impressive. Once again, it talks about you and your upbringing and how you were, and the fact that Mr. Lee, since considering that Mr. Lee was really one of the who gave the information and I'm gonna I have to stick to my scope here now, for personal information to the other co-defendants that leads to the victim one of the victims losing their life, another victim who required extensive surgery, all over a marijuana heist or ripoff, if you will, that went sour to two people that Mr. Lee knew and had personal information of. Therefore, in that, Mr. Lee's release at this time deprecates the entire, in my opinion, after reviewing this file last night, would definitely deprecate the seriousness of the offense. And my motion would be to deny this parole at this time, considering that this was perpetuated through the information given and accelerated through the knowledge of Mr. Lee. I would ask for a denial of this parole.
Second.
I'll second the motion.
Motion's been made and seconded to deny parole. Amy, would you please take the roll?
Mr. Boland,
Yes.
Mr. Coates,
Yes.
Mr. Delgado,
Yes.
Ms. Kloboker,
Yes.
Ms. Goff,
Yes.
Mr. Grubbs,
Yes.
Mr. Heaton,
Yes.
Ms. Schaffner,
Yes.
Ms. Taronis,
Yes.
Ms. Tyson,
Yes.
Mr. Tupy.
Jeremy, I'll be in touch with you. Ladies and gentlemen, thank you for your attention this morning.
And they unanimously denied 11 votes to none. And if you could imagine, I think if there's one takeaway from this, it's that, at least for me, the surprise that Illinois is tougher on crime than Iowa. Illinois is tougher on crime than Connecticut. In some ways, Illinois might even be tougher on crime than Louisiana. Definitely Utah. And isn't that interesting? Out of all the states we cover, we seem to see time and time again where they deny a man who had served already 10 years of his 18-year sentence, a man who, by all accounts, has done great in prison, no write ups, in work release, doing everything he can to rehabilitate himself. I mean, I would even argue that he is no risk to reoffending, that he is no risk to the general public. And what more good can he do locked up? But here we are, Illinois, with the denial. And this is an interesting case. Now, however you want to feel about it, I think that this is an interesting case. Out of the 4 that were initially charged here, we had 2 that took plea deals, 1 that was found guilty by a jury because he did take it to court, and then 1, the man who fired the gun, found not guilty. And we'll go through all the information because Lady Holly provided the research, called out this case. It was actually teamwork. I see Sir Richard there in the spreadsheet as well. And, you know, again, I have to give a special thank you to them because we record hundreds of parole hearings every week. And it's their work that makes it possible to even know to look at this case and then to have the research to piece it together, because at first glance, it is just confusing. Now, some things that I want to get off my chest in this unpacking, and this unpacking, it can be a long one. So, you know, buckle up, hang in there, and I think that it deserves all the research, all the unpacking, so that we can get some clarity on this case. But I'll start first with his attorney. And this isn't the first time that we've seen his attorney. We've seen him. He represented the woman who killed her mother, her father, and her brother many, many years ago. And if you haven't seen that one, check it out in the Illinois playlist. It's a case that needs to be seen. I felt that he did a disservice to his client in this case. I did. For one, you can't leave your phone on. That is inexcusable. 2, you can't have a ringer like that. I mean, it literally sounded like he was carrying around a 50-year-old, phone with him. I thought he was going to pull this big block phone out of his bag and take it off the hook. Number 3, and maybe this isn't so much his fault. He didn't know that the DA wrote an objection. It could be that simply no one notified him, and I don't blame him. Look, if you don't hear from the DA, are you really going to reach out to the DA and wake a your sleeping adversary? No. So maybe that's, not his fault, but it doesn't look good nonetheless. Then the idea that he played off the fact that his client did indeed tell him to bring a gun, he kind of played it off like, and that's not, don't play it off. You're here to admit guilt. His client wasn't denying any of it. You shouldn't deny any of it. We know what the parole board wants to see. They want to see you took a plea deal, you admit to it, own it. And he didn't do that. He tried to play it off. And then he says, I this is what I thought I had heard, but he said, my client, I didn't think he was guilty of first degree. I tried getting a deal for him, but the DA, they didn't want to. They thought, no, even with the gun enhancement, even though he didn't have the gun. And again, that's just not how the system works. I mean, I for one, for me, it could be easy to believe that he was what, like 18 years old in community college. It could be this all just seemed like a game. He asked his friends who he knew. It could have been he thought he was being cool. He thought he was being gangster by using some slang like bring a what do they even call it? A pole, bring a pole, you know, and this is going to be an easy hit. And then his friend brings this dude who it seems that no one really knew, who pulls out a gun and blasts them. And this was all for 2 ounces. 2 ounces, which he, the man who we just saw, never even got. So when they blasted them for the 2 ounces, they then took it, left, and then they divvied it up between themselves. But he, the man who we just saw, he never got any of it. And like I said again, it just, and then another point I want to bring out, which is it's pretty sad, right? His parents didn't show up to be there in support of him. Now, they said on the record that they were going to let him come home, but they didn't show up to his parole hearing. And the group of people behind him, I don't believe they were there either. See, in this day, they had a long docket. They had many parole hearings. And at the end of this hearing, one of the parole board members was caught in a hot mic. I didn't play it because it just didn't seem so relevant. But he said, I mean, it's relevant, but it was just, I don't know when I could play it. Maybe I could play it for you now. I don't know.
Who are all these people up there for? Are they?
But he basically said, "Who's all these people here for?" That's what one of the 11 parole board members was saying. Who's the? So I don't think anyone shows up for him. And let me just go over to bring some. We can go over a lot on this case, and I'm trying to think how to do it. So let's start. They're just like babies here, and then you see the pictures of them now, and it's like prison transformed them, and it's crazy. You know the people they killed were still seniors in high school, 17 years old, just trying to like how many of us knew someone in high school that's dealing pot? It was 2 ounces of pot. It's so insane. So this is the man who decided to take it to jury. He was found guilty. This is who that was. You can't recognize the 2 people right here. You go from kind of like high school kid, whatever, to this. It's just insane. And so here it is. Jury finds men guilty of murder. And this was 2018. The court, the wheels of justice move a little slowly. Now, a jury found David, I remember his name, guilty of first-degree murder of Max Gadou and attempted murder of his companion. Both were 17 years old. Students at North High School when they were shot on September 28, 2014 during a marijuana robbery. This reminds me of Judge Brady from Florida, right? Who always says, that unlethal, unviolent drug. Admitted arranging the deal, but insisted he had never intended to involve the use of force. The Cook County jury found that he was legally responsible for the killings because it took place during a violent crime in which he participated, even though he did not pull the trigger or intended anyone to die. He mouthed something to himself silently before the 7 women and 5 men of the jury returned with a decision. After about 6 hours of deliberation, his friends and family quietly saw that the verdict was announced: guilty of first-degree murder and guilty of attempted first-degree murder. Oh, on that note, his attorney made another mistake. Which is in right. This was a big one. He's caught in a lie, what seemed like a lie, where he said, "Yeah, my client, he testified because he knew it was the right thing to do to act witness against the shooter who was found innocent." And then they're like, "Well, what do you mean? It was part of the plea deal." And his attorney says, "Well, yes, it was a benefit in the plea deal, but it was a condition of the plea deal. But I didn't think that it was a benefit." And the parole board is just like, "Huh? No." And again, That's inexcusable from an attorney because it seems like you're not just admitting what it was. No, that's not true. And that's probably the leading role in why the jury didn't find him guilty of pulling the trigger, because all his defense attorney would have to have done is said, did you receive a benefit from pleading against my client? And they would say, yes. And then they would say, no more questions. And that's probably what found him innocent. The jury just didn't want to deal with it. They didn't think there was irrefutable fact except having witnesses that received a plea deal. So, anyways, after about 6 hours of deliberations, family quiet. It only took 6 hours. It's like enough time to have like lunch and, you know, a bathroom break, and maybe then even get some Chinese food for dinner. It's crazy. Speaking after the verdict, the parents of the murdered teenager expressed relief. Also, who we didn't see here were the victims, and there could be any number of reasons why they didn't show up. But in Illinois hearings, we have seen victims show up and make statements. So it is something they offer. Have been coming to court every month for the past 3 years as the cases of those caused the killing of their son have progressed. Think about that. They were there every month for 3 years. If it had gone the other way, I think our hearts would have been more broken than they are already. There are no winners in this, Patricia said. I'm just thankful that he will not be out there to do this to another child. She said, justice was served in this case. Throughout last week, the jury heard from prosecution witnesses, including 3 confessed co-conspirators, cops, and their surviving victim. Defense attorney called their only witness to the stand on Monday. He donned makeup throughout the trial to conceal a teardrop face tattoo. Oh, the guy put on a teardrop face tattoo. Oh, okay. Well, that's something. He puts on a teardrop face tattoo. Oh, there it is. Look at that. So this punk was proud of it. That adds color to this trial. You know, we have a Utah hearing where there was somebody donned a teardrop tattoo. If you haven't seen it, that's worth hearing. Also, this dude walked into a place and just shot a kid for no reason. Schmuck. Who donned makeup through the trial to conceal a teardrop face tattoo, testified that the shooting was a result of bad luck. He said his plan had been for one of the 3 teens he drove from the South Party to snatch $500 worth of devil's lettuce from a girl who attended Niles North. She asked her acquaintance to come along to provide protection and support during the transaction. Antonio Hicks shot both teenagers. The defense and prosecution agreed. Hicks, then a 17-year-old Chicago resident, was released after his initial arrest but charged as an adult in February. So they were saying, I don't understand. The jury asked to decide if the shooting was a result of a robbery he participated in, but prosecutors pointed to the message he had sent to friends for days, speculating about robbing narcotics dealers. Me and Nick, in need of a stain. You think Janet is sweet? Advocate asked. Nick pled guilty to a reduced charge of aggravated battery involving firearms in exchange for his testimony and sentenced to about 20 years. Stain witness testified is slang for a term of robbery. 2 of the other 5 people who were initially charged with the murder, Jeremy, Miles, and Hughes, have also accepted plea deals and testified at trial. Cook County Assistant State's Attorney Michelle Gemsky said that Advik had put the whole plan in motion. She listed each of his actions that led to the double shooting. Advik texted the victim 49 times to set up the deal, agreeing to the time and location, but moving it when she suggested a spot that was too hot because it was near a fast food restaurant. He assembled a team, drove them all up to Skokie from a West Englewood barbecue. He identified himself as Niles North student named Tyler, according to the text messages. Prosecutor said as he picked out Hughes to pretend to be the student and then parked his car ready for a getaway. You know, these kids, these high school kids, had no idea. They thought they were like just giving, like it's not like $500 worth of devil's lettuce. Like it's, come on. He was, you know, they thought they were just doing it to people they knew. This wasn't supposed to be dangerous. He was always ready and waiting to whisk those individuals away from the crime scene. She asked Advik had not intended for, I can't these names, I just can't, to die or plan to kill him, was nonetheless responsible for his homicide and the shooting of his companion, whose life may well have been saved by a witness who ran out of the street to hold her neck up. That allowed her to breathe after Hicks shot her in the face before running back to Advik's Chevy with Hughes, who needed to be reminded to grab the narcotics. They almost didn't take it. And remember, Hicks is this man who was ultimately found not guilty. So because his trial only came like two years ago or something, was when it. Okay. So what's interesting is that in the guilty plea that this man, man was found guilty, the jury even denied with those course of events to what he was guilty of. But I don't know, maybe that will be part of his appeal. Who knows? The victim, now a college student, was able to point out Hughes in a photo array in the aftermath of the shooting while hooked up to a respirator and unable to speak. Gato was shot first, suffering a gunshot wound to the back. His companion was shot in the face and survived after a lengthy hospital stay. I don't get it. If she was able to point them out, how is that not good enough evidence for the jury? They had a survivor. Weird. Juries are just weird. As attorney Damon Sharonis presented the closing argument for the defense, he said, Gato's death was a tragedy that shouldn't happen to anybody. Sure, I'm sorry for not pronouncing the names right. I just can't with these names. Sharonis placed responsibility for the killing entirely on the shoulders of Antonio Hicks, saying the forensic evidence left no doubt. He suggested prosecution witnesses all agreed that Advik had not intended to carry out the robbery. Antonio Hicks decided to turn it into one without telling anybody. The issue, whether or not Advik knew about the robbery was going to occur, which he said prosecutors had failed to prove. There are questions left unanswered in this case, he said. Advik was a witness to something that was horrible, but said his client did not foresee it and was not legally responsible for it. There is a difference between hustling somebody out of weed and pointing a gun at someone. He said Advik had wanted to use counterfeit cash to steal the weed, as he had done in the past, but was unable to get a hold of the bills beforehand. Nobody wants you to say you've got a great genius idea, the defense attorneys told jurors. In fact, you should be disgusted by that. Nonetheless, he argued that the prosecution had failed to prove beyond a reasonable doubt that Advik intended to take the marijuana by force or the threat of force. This started as a scam to get the marijuana. No force, he said. Delivering the prosecution's rebuttal, Assistant State's Attorney Robert Helling-Goder said that Advik had assembled his A-team of accomplices ahead of the robbery. They were all involved, and they all shared responsibility in the death. Who brings one extra witness to a crime unless he's part of the crime? Asked the jury. Who brings a complete stranger to share in the proceeds of your 2-ounce crime if you're not part of the plan? How about a bunch of morons? Although Advik said if he had wanted to steal the weed from the victim, he would have done it alone, the prosecutor suggested he had recruited others to take part out of fear. He's a coward. He hides behind another name. He said he's afraid to get out of the car. Peter, the victim's father, said he believed the state had a strong case and the defense had been trying to offer up a Hail Mary by arguing the plan had never been committed to commit robbery. It became pretty clear, at least to me, that this was pretty well planned out. It was pretty well thought out, he said. The defense argued the fatal result of the drug deal Advik admitted arranging were unforeseeable. He made up his cockamamie idea to take the marijuana without using force. Sharonis said this was not a planned robbery. Instead, at some point, Hicks decided to carry out an armed robbery on his own without telling anyone he had the gun. I actually believe this. I don't believe these kids. The felony murder rule in Illinois, among the broadest of the country, holds anyone combined to carry out forcible felonies such as robbery, whether armed or not, responsible for any foreseeable deaths. Those found to be involved in certain felonies can be charged with the murder of an unarmed Confederate, even if that person was shot by an armed bystander or killed by police in a fleeing vehicle. Again, this brings out some facts that many don't know about Illinois. Illinois has this reputation of being super loosey-goosey on crime, but Maybe they are in certain cities, and maybe they are with bail reform, and maybe, but once you get locked up, we just haven't seen that when it comes to the parole board, at least. Judge Lorraine again rejected a request by the defense to mention foreseeable element in instruction of the jury, blah, blah, blah. Let's see if there's anything else. They called by the state to testify. Advic, 3 admitted accomplices said that they had arranged the deal. None of them said that they saw Hicks with a gun, although Smith said he knew the accuser shooter to carry a firearm and noticed him grabbing an item in his waistband that night. Cell phone records and surveillance video indicated that Advic, near the scene of the night of the homicide, and photographs of the girl's blood-stained phone indicated that he had called her right before the deadly encounter. Crime scenes photos of the bloody interior of the victim's Honda showed a replica handgun left behind after the shooting, although it was not established whether or not the victim had drawn the weapon when she was shot. The murder weapon was never recovered, although ballistic evidence found that both shots were fired to the same gun. So that fake gun could have been from one of the perpetrators, or they're saying that she had a fake gun. This is interesting. There was a fake gun left at the scene. Hicks' fingerprints were found on the rear passenger side of the victim's car. Spent shell casings was found nearby in the grass. His fingerprints were found on the rear passenger side of the car, and spent shell casings found nearby in the grass. He's awaiting trial with charges of first-degree murder and attempted first-degree, and did not testify at trial. And remember, he was found not guilty. Advic, who has remained in jail since October 2014 arrest, faces sentence of life in prison. I think he ended up getting 30-something years. And this is who was killed at 17 years old, murdered. It's here's where he's found not guilty. Let's see, where are we? We're already over the 20-minute mark. Chicago Manning prosecutor said pull the trigger 2014 Niles North High School student. Remember, this is written 2021. Took a while to get him through trial. Another teen was found not guilty. Antonio Hicks, 24, was charged with first-degree murder and attempted murder. The trial started out September 14th, and the case went to jury on Thursday. On Friday afternoon, the jury returned not guilty verdicts. What are they saying? How long did it go for? September 14th? So I guess it went 10 days. 5 people, including Hicks, were originally charged in connection with the shooting that killed 17 years old, injured his female friend. Prosecutor said that the shooting was part of a deal gone wrong. The group planned to steal $500 worth of cannabis, who was shot in the face and seriously wounded during the robbery. All the other defendants either took plea deals or went to trial, including Advic, 26, who was convicted of first-degree murder, attempted murder in 2018, and sentenced to 35 years in prison. Prosecutors alleged that Hicks was the person who actually shot, and Spitz, the other 4 defendants, were charged because under the law of accountability, they helped plan and commit the robberies. But during the trial, public defenders argued another member of the group shot and killed Spitz. They also said that there was not enough evidence to convict Hicks, and that the witnesses who testified were unreliable. Advic knew, blah, 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 and informed the plans to go to Skokie, splits the 2 ounces of marijuana, prosecutors said at the time. They said that the group agreed to meet Spitz in the vehicle in front of the home at 9200 block and supported the protection during da-da-da. Hughes testified that he got into the car with Hicks, and that as soon as Spitz pulled out the 2 ounces of marijuana, Hicks shot him through the back seat and then shot her in the face. Hughes and Hicks grabbed the cannabis, ran back to the car, and drove to Chicago with the other 3 men. The 5 were arrested and charged a short time later. Again, we saw the parole hearing of the man who wasn't even there. During sentencing hearing for Advic in July, Patricia Maxwell Gadou's mother told Advic and the court about the terrible trauma she and her family lived through after the murder, about the plans about how their son had planned to become an engineer. How does one begin to describe the murder of their child and the toll it's taken on them and my family? I imagine dropping your child off at a friend's house in the afternoon and then receiving in a text earlier that same evening that he's been shot. The family cannot be reached for comment. Can you imagine if you believe that the man who shot him actually got away with it, got away with the murder? There is an appeal for the man who, it was just decided June 2nd, 2023. For the man who was sentenced to, 35 years? There's a lot of information in here, but frankly, I think we've gone through enough of it. Although you probably get a lot of the details. I'll put this link in the description if you want to do your own deep dive. I always struggle with how long to do the unpacking. I want you to know there's one aspect, which is I want to get you as much information as possible. There's the other aspect, which is I know that there's only so much that one can digest. And then there's, for those of you, I see some right in the comment section, you just want it to be long so you can make more money. And it's like, no, that's not how it works. The algorithm hurt every percentage of an upload that I load that is not watched. So if I upload something and 50% of it is watched, YouTube algorithm punishes it. If 90% is watched, the YouTube algorithm rewards it. So the longer I do the unpacking, the more punished the algorithm will make each upload because fewer people watch it to the end. Let's be real. So I want to set the record straight. I am not doing this to hear my own voice. I'm not doing this to improve this. I'm doing this because I want to do this case justice and pass along the information that Holly and Service found for me. So let me just get that off my chest. And I just think this is just a tragic case. However you feel, whether they should have paroled him or not, the bottom line is that two 17-year-olds were killed callously for no reason, over nothing. And a jury found the person who they believe, prosecution believed, pulled the trigger to be innocent. It's just messed up. It's just everything is a waste. And you might say, well, he was guilty in reality, but innocent beyond a reasonable doubt in the court of law. And you might not be wrong with that. They had basically a lot of people who had taken plea deals testify against them. As a jury, would you find someone guilty when everyone testifying? And I don't know if the victim blacked out, and maybe that's why the victim didn't actually know. Maybe the victim got up and said, I don't know who pulled the trigger. That's the only thing I can think of. Although I thought the victim did point things out on the respirator, but I don't know. And there you have it. And with that, I'll let you go.
He was not at the robbery. He was not in the car. He had no idea that Smith and his buddy, who came with Mr. Advick, had a gun. He did not think that someone was going to get killed at this event. But he did accept responsibility for giving this young woman's phone number and saying that she would be an easy target for a robbery because she was selling cannabis and had cash. And he accepts that responsibility. But not only does he accept the responsibility, and not only did he plead guilty to the not murder count of this case, but also he lives every day with the knowledge that a woman was shot and survived, and the person she brought as muscle was killed. He knows he wasn't guilty of murder, but he feels a responsibility for the injury to a person and the taking of a life. And I know that because I represented him in the trial court, and I've represented him until today.
This individual was a couple years older than my son, very much a mentor to Max. So to think that somehow this individual was involved in the murder of my son is devastating.